Appeal Number 10, People of the State of New York versus Hao Lin. Counsel?
Your Honor. Anthea Bruffy for the appellant. I would like to reserve 2 minutes for rebuttal.
Yes, of course.
The introduction at trial of Officer Mercado's testimony about the administration and results of a breath test with regard to the defendant's blood alcohol content did not violate the defendant's right of confrontation. And it didn't violate the defendant's right of confrontation because the people didn't elicit from him any statement or report by the unavailable witness that was offered for its truth. The testifying witness was present for the entire administration of this breath test. He saw the operator, Officer Harriman, push the button. He saw the defendant blow into the intoxilizer machine.
Is it necessary for purposes of the Confrontation Clause that he be able to verify each of the 13 points of the checklist? And if so, did he do that?
It wasn't necessary, Your Honor, and he didn't do that because he testified, Mercado testified, on examination, ironically, by defense counsel, that he did not observe, he couldn't, from his vantage point behind the video machine, he couldn't see the display on the machine, which would have demonstrated that the intoxilizer solution was at the correct temperature. But he did testify that if there was something wrong with the solution, the machine wouldn't operate. He also testified, based on his expertise, that if something was wrong with the machine, there would be an error sound. He was familiar with that sound, and he didn't hear it. So,
but weren't there other elements to the test too? Judge Steiner mentioned the 13-point checklist, but there was the observation of the defendant for a 20-minute period before, and then he didn't verify the solution temperature as proper, entering the info, see the printouts from the aborted test. None of that stuff was done. Yeah, well,
he did observe, he was present for the 20-minute observation. So
you did observe them during that period?
He did observe him during that period. But
that's not part of the videotape, though? No,
it was part of his testimony.
Oh, was it? Okay.
So, but that really, the appellate term, it's sort of a red herring, because the Confrontation Clause requires that any testimonial statement that's admitted at trial, the person who made that statement has to be available for the defendant to cross-examine, to confront. And here, unlike Bullcoming or the case that the appellate term relied on, no testimonial statement was elicited through Mercado of Officer Harriman. The printout was entirely machine-generated. Harriman pushed the button, the printout came out of the machine, and Mercado testified from his first-hand observation that this was the printout that had come out. He saw the printout come out, and he testified in court, this is the one that came out, and it was admitted into evidence. It's People's Exhibit 8, which is reproduced in our appendix.
Wasn't there an allegation by defense counsel in one of the objections that the reason that the officer wasn't present, it had something to do with some impropriety with other testing before, and he left the department and went to Boston after that?
Well, that was totally hearsay and unsubstantiated. The testimony
But you could see why you'd want to cross-examine somebody on that issue.
Of course, he would certainly want to cross-examine, and he was free to call him. But if no testimonial statement of Officer Harriman is admitted, it's not a right of confrontation problem.
But isn't the point of the printout all that testimony about going through the checklist, how this machine works, my expertise, that I've done this before? Isn't that what makes the printout meaningful?
That has to do with the printout's foundation. And the people provided a knowledgeable expert who had expertise and was certified in the operation of this machine. So the defendant.
But then the other part is the observations, right?
Yes.
It's that he's experienced, he knows the protocols, he understands the
Yes.
procedure, he's used this machine in the past.
Yes.
I grant that, all of that. But then the question is the observations, which are what you're getting these questions about, what is it that he observed? If we disagreed with you and said that the appellate term was right, that there weren't the observations that you're arguing are there, do you lose?
No.
Why not?
No,
That's what I'm
because
not understanding.
this is
Why
a
not?
right of confrontation claim. This is not a compulsory process claim. They're claiming that we, the people, introduced into evidence a testimonial statement, which is what Crawford says the Confrontation Clause is violated by. What are they saying we introduced? We introduced a printout. There's no statement of Officer Harriman in that printout.
So you're distinguishing that from the cases in which there is some sort of a report that is completed by
Correct.
a human being based on something else, not something
Absolutely.
that comes directly out of a machine, which you say has a different...
Absolutely. And I'll give you two
Why-
examples.
Why is that
Bull
different?
Cumming. In Bull Cumming, the Supreme Court had a blood test where for want of a better word, the people, or the state, introduced against the defendant a forensic report with regard to that blood test. The analyst who had compiled, certified, all those things, that report was not called. A substitute analyst was called, who had absolutely no contact with the test at all, which, of course, is very different from this case, where we have our witness who observed the whole test and had expertise in it. But the difference is that in Bull Cumming, that report was made by the analyst. The analyst certified it. Here, Officer Harriman didn't make this printout. Officer Harriman did certify it, but that certification, which is reproduced in Respondent's Appendix 1, was never admitted into evidence. So
you're saying that if Mercado wasn't there at all, he
correct.
could testify to the foundation for this document?
Yes.
And that would be sufficient?
That would be sufficient, but somebody would have to, of course, testify to having seen the test occur, because there would have to be some firsthand observation of the test.
So here
But-
we have, I'm trying to understand your response to Judge Rivera's question. Here, Mercado happens to be that person. He does
He was-
both. So somebody would have had to do that, but not
Yes.
Mercado. Is that what you're saying?
Yes, Mercado in this case was the best possible person, because he was an expert in this machine, and he personally observed the whole process, and he saw the printout come out.
So could you have 13 different people testify that they observed each one of those 13 things on the checklist?
You could, but this is not a confrontation issue. This is more a foundational issue. The 13 things on the checklist have to do with whether the machine is reliable. You can have the
So are you
defendant...
saying, counsel, that whenever a machine produces a printout, that would not be a confrontation issue?
Yes, as long as somebody with enough expertise and firsthand knowledge is available to be cross-examined on the machine's reliability. And we certainly had that here. I mean, the Mercado was cross-examined by the defense on how the test was conducted. And as I said before, the one issue with regard to the heat of the solution was brought out by defense counsel. So how can you say that his right of confrontation was violated? I think the defendant is bringing up foundation and compulsory process, and maybe even sufficiency, but it's not bringing up a confrontation claim.
Thank you,
Because there was no statement.
Thank you. Counsel?
Good afternoon, Your Honors. My name is Denise Fabiano, and I'm here for Respondent Hao Lin. There were two testimonial statements here. You have the printout, and you have Harriman's statement at the end of the video saying it's .252. Their testimonial, the printout's testimonial, as is the statement.
But who can testify as to the printout if it's the machine's not going to testify, right?
No,
So-
it's Harriman's statement.
Right.
That machine printout, first of all, it is not entirely machine-generated. Make no mistake. There is human interaction with the machine and human input into this testing process.
So it's a human who's going to testify as
course.
to that. printout,
Of
and it's
course.
someone who has some familiarity or has observed something in this process, so why doesn't this qualify?
Because Mercado is simply an insufficient witness. Once, this
Under
printout,
which case is he an insufficient witness?
well,
I don't read Bullcoming to require anything else.
right, well, John says, this court's opinion, and Sean John says, you cannot be a conduit for the actual tester.
But
Yeah, but
even
it's
that opinion says you don't have to call every witness
No,
to
and,
at every
and the
step.
beauty of this type of case is you only have one witness who's observing it. The video cameraman is observing everything. So if he had witnessed the 20-minute observation period to make sure he hadn't belched,
But your
if he,
complaint is he's missed one or more of these 13
He has
steps.
missed-
Not that he could not have done it.
right, he
So-
could have done it. I would have no, I would,
But
I
why
would
isn't
go
that
so
an
far as,
argument that you have to watch every step?
I'm
Which
sorry?
no court has ever said. Why is that an argument that you have to bring in an observer
Right.
for every step of this process?
I'm not saying that either. I'm saying that when you have a testimonial statement here accusing a defendant, proving an essential element of the crime, that it's directly accusatory, that we have to be able to test the reliability of that conclusion. That's the confrontation
Right,
violation.
But the issue is, what do you need to satisfy that?
You need a sufficient surrogate witness who witnessed the essential steps that go to the reliability of that test.
So your argument is they missed an essential step, not that they just missed some steps.
Right, and that's my argument here. I'm
What
not
was the
saying which of
essential
those steps would be
step?
essential.
Yeah.
I can't tell you that. We don't have a sufficient record here, and we don't need to go that far here. What we do know is that 2 steps were missed, 2 steps that Mercado said were integral, that were essential to the integrity of the reliability of the test. He testified to that.
And he
didn't-
testified as to the observations he made.
Right.
Which would establish those steps. It may not have been the exact same way, but he was present and he said, this is how I know from being there. This is what I heard, this is what I saw, this is what I didn't see, and this is what I didn't hear.
Right.
And based on my experience, that means this.
First of all, I don't think that's entirely accurate. He did not see the crucial 20 minutes. He admitted he wasn't watching him. He wouldn't have known if he burped silently. He said, I didn't hear anything. I wasn't watching him the whole time.
Well,
It
he
wasn't.
said that it wasn't necessary to have your eyes fixed on him for every
No,
bit of those 20
he did not
minutes.
say that. He said, that was not my job. You do need to watch him for 20 minutes. That is an essential step. Because if he belches,
So if-
burps silently,
So if the
regurgitates,
person responsible sneezes and turns his or her head and takes their eyes off of the subject for, whatever number of seconds that may mean, that then the test is no longer reliable?
well, that's what we would want to confront on. How much did you see? We want to make sure, we want to make sure that he didn't do that.
I thought Mercado said, I would have known if he had vomited, if he had burped, if he had eaten something, if, whatever, by the amount of time I was watching and listening.
No, I don't see how that's possible. He said, I was present in the room, I did not watch him the whole time.
But you could cross-exam on that.
He said, I did not watch him the whole time. Yes, but Harriman was tasked. He's the one who initialed that step. He did theoretically, I hope, watch him the entire 20
Yes, but
minutes.
if Mercado had, let's say
If
we
he
disagree
had-
with you, if he had, then that issue goes away.
Yes.
Okay, so did the appellate term
The appellate term
find that
found...
he had not watched them
No,
for
the appellate
20
term
minutes?
didn't reach that specific step. They built it on the 34 degrees, which I would also submit, the machine would not shut down if the temperature were not 34 degrees.
Where's the proof of that in the record?
Well, we only have Mercado's statement that the machine would shut down if something improper occurred. Okay, that's a very generic statement. I'm going to submit to you, the record doesn't indicate that it would shut down. We have a blank space for the technician to fill in. Not just a, yes, it was 34 degrees. What was the temperature? You have to fill it in, 34 degrees. That's number one.
All right, but if he testifies, it shuts down, and I know that because it makes a noise, I didn't hear that noise. Why isn't that enough?
It theoretically could be. That didn't happen here.
Why didn't it happen here?
I don't know. It wasn't elicited. He
But
didn't say that.
You're saying the testimony would not allow that inference, that that's what he's testifying to?
I don't believe it does. And I don't believe the machine would shut down under those circumstances, and I'm going to go
What's the point
further.
of the testimony about a sound that indicates that the machine
Because
has
there-
aborted?
Because
Why
there
would
are
he
other
testify to
things
that?
that would make it shut down: insufficient airflow, improper blowing,
But
tongue.
that testimony is at the time when he's being asked about the temperature.
He was being asked about the chemical solution, the composition of
No,
the
there's
chemical
two different
solution.
sections. There's testimony on the solution, there's testimony on the temperature. The temperature is the one where he's talking about the sound.
I think it's equivocal, Your Honor. I think if you reread it, I do think it's equivocal. I think,
We disagree with you. Do you lose?
okay, no,
Why not?
because we still have the 20-minute observation period.
So your rule is then, it's a 100% rule. If they miss anything at all, they're out. Because the language, let me finish. The language in Sean John is a little different. It says conducted, witnessed, or supervised. It doesn't say you must see every single element of every single test. The policy implications of that kind of rule would be absurd.
Absolutely.
So you're not arguing that. So why is this not simply a weight question in terms of the analysis that has to be placed on the evidence that's offered?
It goes to his sufficiency as a surrogate witness, not to the weight, because otherwise you could have somebody come in and say, guess what?
So-
I didn't see any of the 20 minutes. I didn't see
So we
anything.
translate your principle to a DNA setting, say, do they have to, does then the supervisor there have to witness every single test for the full period of time, otherwise it's not admissible?
Obviously, the DNA setting is much more
I
complicated,
realize
and
it's a
it
little.
involves
it's-
many more
it's-
analysts.
No, I give you that, it's certainly, it's
I
not a-
guess off the top of my head, I would argue that it certainly that they do need to call the people who witnessed the aspects that go to the reliability of the
You read
test result.
Sean John is saying that we would have to do that? So let's say you'd have to
No,
bring five
no,
or six people in?
No, Sean John says that you have to call somebody who witnessed, supervised, or made an independent analysis on their own. But you cannot act as a conduit for the person who should be tested, or who, the out-of-court, the non-testifying
you
So
witness.
say-
then what
counsel?
is it exactly that Officer Harriman would have provided that Officer Mercado
That he
wasn't
saw
able
that
to-
the temperature was 34 degrees, and that he observed this defendant for the requisite 20 minutes to ensure the reliability of the actual test result, which is what our right to confrontation
Counsel, what do you
promises
think
us.
Justice Sotomayor meant in her concurring opinion in Bull Cumming when she said it would be a different case if, for example, a supervisor who observed an analyst conducting a test testified about the results or a report about such results, meaning that that person would be a sufficient surrogate. So how's Mercado different from that?
Mercado is different because what Sotomayor is saying, and I'm not quibbling with, a surrogate witness can testify. They just have to be an adequate surrogate witness.
Why
Someone
isn't
that we can
Mercado?
actually confront on the essential steps that go to the reliability of this test.
And Mercado's not adequate because he didn't have constant eyes on defendant?
That is the rule for the admissibility of these tests. That's what goes to the reliability of the test result. That's what, they prove the case with this number.
Well, you're claiming two. You're claiming the 20 minutes and you're claiming the temperature.
Both. So what we have here, we have
So
these,
what would you suggest that we decide regarding what a DUI testing unit has to do? There has to be somebody videotaping as well as somebody else watching for the 20 minutes? or what?
I'm not saying that the videotaper can't be. Mercado could have been that witness. He could have been that witness. He just missed a couple things here. Going forward, if you want to be able to call, particularly where we're raising the reason why this tester left the office, we argued or alleged that this tester left because he had improperly conducted IDTU tests. And obviously Mercado can't testify to that as well, but he can't testify to this person's, the integrity of this test result. And that's what we have a right to confront on. And I'm going to go so far as to say, well, I'm sorry, let me back up. The 34 degrees, I just want to get back to that. There's, on the simulator solution certificate that
Let me
was,
ask you this. If the appellate term didn't refer to the 20 minutes, why can't we assume that they concluded that his testimony was sufficient? Are we bound by that?
no, we're not bound by their rationale. And it could
You're
just
just
be a
saying that's
case.
not a fact finding on its own?
No, an omission is not a fact finding. And you only need one of those things, so they, whatever one they reached, and the other one, you're certainly free to consider. And I just want to finally say, This case is unlike any other case because law enforcement is the one that did the testing here. It's not an outside private lab. This is obviously testimonial and very accusatory because we do, this the only case that I'm aware of where law enforcement, or I mean of the Confrontation Clause cases, where law enforcement actually did this test.
Thank you, counsel. What about counsel's argument about their inability to get to the meat of this thread that Officer Harriman had some integrity issues with respect to the performance of those tests?
Well, there's, according to Officer Mikado, Officer Harriman left because his wife had been transferred and he moved to Connecticut. That's all that there is in the record. There was an allegation made by defense counsel, unsubstantiated, that there was a memo floating around in the Legal Aid Society office or in his office, but was never produced. So we don't know. But it's irrelevant to this issue because no statement by Harriman was admitted into evidence in this case. So basically, it's what they're raising is a sufficiency claim, an unpreserved sufficiency claim. And Sean John dictum in this court's recent Sean John decision actually supports our position. The people aren't required to call on even where a DNA report, which is testimonial, is admitted into evidence. Here, there's no testimonial statement admitted into evidence. But even in that case, testimony of an analyst with requisite personal knowledge who has witnessed who has witnessed the test is sufficient under the Confrontation Clause. So here, where Officer Mikado personally observed everything, has expertise, testified to his expertise, and to everything that occurred, these deficiencies, alleged deficiencies in his testimony, go to the weight. And in fact, this could have been the same if Officer Harriman had been testifying.
So if he had said, no, I didn't look at him for 20 minutes,
That
could
would
he
go
have
to,
served as a substitute?
well, he's not a substitute
Let's
for
say we
Harriman.
disagree with you on that issue. Let's say we disagree with you on that issue.
Let's assume
and you need
that.
the substitute.
For
you need the
argument's
person.
sake,
You need Harriman.
although I
Yes, that's what
disagree
I'm
that
asking.
he's a surrogate.
That's the hypothetical.
But hypothetically, if he was a surrogate,
Mm-hmm.
It would go to the weight of his testimony.
If he didn't observe at all.
Well, somebody else, Officer Nadell, was also in
But
that
let's say
room.
that's
If
not
he
the
hadn't,
testimony.
we would have
This is the
presented
only,
his
excuse
testimony.
me, counsel.
I'm
This is the
sorry.
only person who's testifying. And he is asked, did you watch him for 20 minutes? And he says, no, I watched him for 2. Can he be a substitute?
Well, that would be a much closer case, because then, assuming he's a surrogate, he would need to be able to verify the reliability of the test. I still think it would go to the weight of his testimony. But here, as I said, we don't have a surrogate, and we do have somebody who observed. Therefore, the Confrontation Clause
But
is
isn't
not
that weight
implicated.
argument if it was Harriman as opposed to the substitute?
No, because Harriman's statement was not admitted into evidence.
I understand that. Let's say Harriman, you weren't using
It
a
would go to the
substitute, you were
weight.
trying to use Harriman. And he says, no, I didn't watch him for the full 20
That
minutes.
would go to the weight.
Then it's the weight,
I mean, we
you
would
say.
have to prove our case. This is a sufficiency argument, not a confrontation argument.
Thank you, counsel.
Thank you. For that reason, I would ask for the appellate term's decision to be